We'll give people just a second to come into the room. Why don't you go ahead, Paul?
Okay. Good afternoon, everyone. My name is Paul Brewer, and I'm one of the board members. And I have the privilege to introduce our next speaker this afternoon, Nan Gallagher. Nan Gallagher has devoted her career exclusively to the advocacy of healthcare professionals and entities. Ms. Gallagher is a nationally recognized authority and presenter on groundbreaking healthcare topics, and she is sought after for her tireless and dedicated focus on controversial pro-physician platforms. She also has carved out a niche practice for herself, serving as a chief legal officer and chief compliance officer for countless medical practices. Fluent in Spanish, Ms. Gallagher was awarded a United States Presidential Fellowship from President Bill Clinton to study law abroad in Chile. She graduated Phi Beta Kappa and magna cum laude from Fordham University, where she double majored in English literature and Spanish studies. She then earned her Juris Doctorate from New York Law School and served as a judicial law clerk in the Superior Court of New Jersey. Ms. Gallagher is admitted to practice in New Jersey, New York, the District of Columbia, and the United States Court of Appeals for the Third Circuit. Please help me welcome Ms. Nan Gallagher. Thank you, Nan.
Thank you so much, Paul, for that wonderful welcome. It's great to be here, and it's nice to see some of you again. I know we had a presentation in the past, and I really look forward to these because it's a wonderful opportunity to engage with membership, and it really is an honor to be here. So thank you very much. What I'm going to present today is called Hiring and Firing Risky Business. I put this original presentation together years ago. And as Paul gave you some of my background, I am a healthcare lawyer, but I also have a lot of employment law experience, trying over 300 employment cases to trial and verdict. So what I've done is I've put this presentation together and I've modified it over the years. So for those of you who may have heard something similar in the past, you're going to hear some definite updates as I go along, including some highlights that may be relevant during this ongoing pandemic. And I won't bore you with my background. Here's a little bit about what I do, but I love representing medical practices. Some of my best friends and some of my maids of honor in my wedding were medical practice managers. We form such a wonderful bond when I represent practices, because those practice managers are the ones who call me. Maybe the doctor doesn't want to, or he's too busy, or they're sensitive topics. So it's really a wonderful thing to have such robust relationships and lifelong relationships with practice managers. So hiring and firing. It is really always good to have a refresher on this topic. So even though its original form of this presentation took effect a few years ago, I cannot tell you how many phone calls we get at the firm, and I'll tell you just a little bit about the firm, but we get so many phone calls at the firm about how to properly terminate employees. Now more than ever during COVID, but when you think about it, the laws are changing, employment laws are changing, disability laws are changing, discrimination laws are changing, harassment laws are changing. So really to have a refresher or a primer on this periodically over the years, thumbs up to you for sitting and hearing this type of information, because it really does evolve. Now more than ever, especially during a pandemic, the approach a medical practice takes towards hiring competent staff, as well as parting with staff when it's necessary, is so vitally important. this pandemic has presented, in my opinion, a very unique opportunity for medical practices to look at your bench, right? Who's on your team? Who's playing for you? Do you have the right people working for your practice? Do you have duds, as I call it? Do you have people who don't want to come in, people who are mailing it in, so to speak? You don't have people hustling for the team. That's why now we want to look at who's on your bench to see if you do need to make some changes, whether it's adding on additional competent staff or considering parting with staff and terminating or laying off if you need to. You also might need to decide, or may have already decided, to downsize if necessary, or when that's appropriate. But by the way, I should tell you all, I have landscapers coming and going from the office property, so they should be gone shortly. I apologize. This is, really what happens when you work from home, but I'm at the law firm right now. And by the way, just a couple words about the law firm. We're a boutique healthcare law firm serving the tri-state area, but we've got attorneys licensed in various states. We do everything soup to nuts for medical practices. So during this COVID pandemic, when you think about your bench and you think about what needs to change or what needs to be modified, who you might need to add, who you might need to get rid of, it's the timing that matters. And it's also making sure you understand some of the relevant laws that are in effect when you're making those tough decisions. And I'll tell you some anecdotes along the way. Really, now's the time, and always is the time, to make choices about your staff, but also make better choices about your staff. Here's an example. During this pandemic, when practices have experienced unprecedented reduction in revenue and patient loss, many physicians and practice managers have contacted our firm, for example, and said, this person is really just not measuring up. They don't want to come back to work, or it's like pulling teeth to try to get her to do X, Y, and Z, or she is vehemently opposed to getting vaccinated. And by the way, I'm not offering any opinion one way or the other politically as to whether staff should be vaccinated, although it is legally permissible to require staff to become vaccinated for the COVID-19 virus. But the point is, practice managers and physicians will call us and say they're looking at their staff and they're having a tough time with some of them. And there's so many different permutations of that story that I could tell you. And I say, when did you hire this individual? When did you require them to come back? Have you done anything to compel this employee to come back? Have you done X, Y, and Z to make this employee come back? Have you warned them? So when I say make better choices, it's not meant to be condescending. It's just meant to say, be mindful of the choices that you do make with staff. And it's never too late to make proper choices when it comes to hiring or firing your staff. We're going to talk more about this later as it relates to the COVID perspective. But this truly isn't a COVID presentation. It's one to help revitalize your staff and make sure that if you have any dead weight, you part with them properly, and how to add staff properly. So, is it permissible to expand the scope of a practice? You have to be careful when you do so. Pennsylvania follows the corporate practice of medicine doctrine. Only physicians can own medical practices. In Pennsylvania, this is heavily policed by the Board of Medicine. Now, there are some exceptions to the corporate practice of medicine doctrine. I won't bore you with all of the exceptions, but be very mindful that there is this CPOM doctrine that I'm talking about. It's something that if you are going to be hiring different professionals, look at your ownership structure and make sure that you don't improperly expand the scope of the practice. Can a non-MD or a non-DO hire an MD or a DO to work for him or her? No. Physical therapists, physician's assistants, APNs, dentists, and chiropractors cannot expand the scope of their practice that way. If they own the practice, they can't hire someone with a higher level license to become a co-owner. It's illegal in Pennsylvania and various other states, the majority of other states. You cannot attempt to broaden or expand the scope of the field of practice beyond that of the specialties of the owners. So this is something I simply say when you're hiring professionals for your staff, be very mindful of this and the ownership structure to make sure that you don't affront the corporate practice of medicine doctrine in Pennsylvania. So can physical therapists, PAs, APNs, dentists, chiropractors hire others of the same specialty? Absolutely. If the professional to be hired is licensed in the same state they're practicing in. So you can absolutely think of it like a plane. If you're not an MD and you're not a DO, you can hire individuals, professionals for your staff who are of similar licensure level. So I figured I would just put that in your mind in case you're looking to change the professional roster in your practice. Oops, excuse me. Okay. So here's some factors to consider when you're hiring another professional of the same specialty for your medical practice. Is the professional compatible with other professionals of the practice? And really the next few under that are so important as well. So I'm going to go through them, read the list to you, and then tell you why these are so important. So is that professional compatible with the other professionals in the practice? What's his or her philosophy on medicine or healthcare? Is it similar to those who are already working at the practice? Is the individual socially compatible with staff and patients? Is there enough work to keep him or her busy? Will adding that professional help the practice profit, even if it's not in the short term, but it perhaps may be in the long term once they're properly credentialed? Will it add revenue to your practice, or is it going to drain revenue bringing this person on? And that's important also when you're contracting with that new professional, because then when the new professional comes on, more and more young doctors and other healthcare professionals are really heavily negotiating. And from contracts I've been seeing, a lot of these young professionals or new professionals coming in, they are expecting higher salary, whether it's base salary or incentive-based compensation. So you have to make sure that what's being offered to that individual is not going to drain the practice's resources, and that it measures up fairly and equitably for compensation. Can the professionals of the practice tolerate another opinion? So for example, if you're an MD practice and you are bringing on another MD and of a similar specialty, has it been 3 partners all along? Now there's going to be a 4th. Well, what does that do to the tie-breaking mechanism that might be in place with the partner management of the practice? Do you want to hear another opinion, so to speak? So you think about that as well. And then can the professional of the practice tolerate the potential decrease in autonomy? So sometimes when you hire a new professional, there's more of a team structure and there's less autonomy in decision making. There's less independence in what you can and cannot do. So these are all the types of philosophies and measures that I always tell a medical practice to think about when you bring on another professional of the same specialty. And like I said, in looking at this list, most importantly for medical practice, and sometimes the doctors of the practice don't see this, it's the practice managers who do. Many times it's not the right fit personality-wise. Now you may say, well, or the doctor may say, well, we're not hiring based on personalities. This is business. It's not social. But in reality, you spend more of your waking lives working at the practice, working together. You want it to succeed. Maybe it's been a challenge. I'm sure it has during COVID. But if you bring someone in who is awkward, unfriendly, harassing, dry personality that doesn't jive with others, perhaps too serious, which is not necessarily a bad thing. But if it does not fit with the personalities and philosophies of the other professionals in the practice, that can very quickly develop into a recipe for conflict. And all of a sudden it's different cliques or different factions within the practice complaining about this person or complaining about that person. So you want to be very mindful that this individual you bring in has enough work to do, is properly compensated for the work they're doing and the level of experience they have, that their personality and philosophy does meld well with the team, and that the owners of the practice can really tolerate, if this person is going to have decision-making authority, that these partners can tolerate a little bit of, crowding, so to speak, in the decision-making process. Here's some more factors to consider when hiring someone of the same specialty. Can the egos, and I'm not saying there are egos, but can egos, if there are them, tolerate some patients preferring newly added professionals over them? I see that all the time. You suddenly bring in a new physician, whatever his or her specialty is, maybe it's the same, maybe it's slightly different medical discipline, and all of a sudden you want to keep that professional busy, so the new professional is taking on some of the patients. And then kind of like when you go to your hairdresser, if the hairdresser is out sick, maybe someone else is seeing you at the salon, so to speak, and you really like the way that that individual did your hair or provided service to you, and you want to go to that individual moving forward. It's a little awkward. Happens all the time in medical practices. In medical practices, sometimes when trying to keep a new professional busy, physicians will delegate certain patients or new patients to that individual, and those individual patients want to stay with the new doctor. So can the egos tolerate that? Can office personnel be shared between existing personnel and the new professional? So is there enough staff to cover all of the physicians? Is there going to be a realignment or reassignment of job responsibilities among staff? Some people don't like that. And you as a practice manager may have to police that a little bit. So these are things you want to think about beforehand. These are the collateral decisions that sometimes are not made when hiring the individual. They're made thereafter. They're reactive, not proactive. Also, and just to round this off, what would the costs be involved in adding this professional? Will there be more costs associated with supplies or EMR or certain record keeping requirements, coding requirements? Is there going to be marketing costs expended to bring that individual on and to get the word out? So think about the costs that may incur for supplies, machines, marketing, all of those things that I mentioned, because you should really think about it before and not after. And then there are potential enhanced liability risks whenever you bring any new individual on. And we'll talk about in a few minutes different things you can do to help minimize risk to the practice when adding a new staff member. Just a couple words about restrictive covenants when talking about contracts with professionals. They are permissible in most states. Restrictive covenants are permissible in Pennsylvania. And just for those of you who are really not familiar with what a restrictive covenant is, it's essentially a term in a contract that will spell out the rules of engagement if that individual was to separate thereafter from the practice, whether they left on their own or they were terminated. A restrictive covenant will say things like, you cannot work within 10 miles of this practice or any other practice location of ours that you worked at for a period of 2 years, something like that. So it has corporal and contemporal requirements to it. Also, I will tell you that when restrictive covenants are placed into contracts, there are other types of covenants, things like non-solicitation of staff. If you leave, you can't ask staff members to go with you for a period of X years, or patients, trying not to solicit patients to come to your practice if you leave, for example. So they are permissible covenants, that is, in Pennsylvania. In order for a restrictive covenant in an employment contract to be enforceable in Pennsylvania, the contract must be incident to employment. So you would see it in an employment contract. The restrictions must be reasonably necessary to protect the employer, and the restrictions must be reasonable. So the whole purpose of having a restrictive covenant is really to protect the practice. You've invested in this doctor, you've given them access to your patients, you've given them information as to your coding techniques or your trade secrets or intellectual property. You've invested in marketing for them, you've exposed them to how things work in your practice, and you want to associate some type of monetary component to that. And if the individual just ups and leaves, you want to basically say, hey, for a period of X number of years, which must be reasonable, and X number of miles from where you've worked, you can't work. You can't set up shop and then become our competition. So you do need to have reasonable time and space restrictions. Most courts, not all, but most courts will consider 2 years, 10 miles to be reasonable in terms of geographic restrictive covenants. I've seen some courts go down to 1 year, 5 miles, but that's few and far between. Also remember that no one owns your patients. Patients truly are free to go to wherever they want to go. Your practice doesn't own them. So even though in an employment contract, you may have a provision that says, you cannot solicit our patients for 2 years, that's all fine and good. But if that doctor is leaving, whether he was terminated or decided to resign, he may not solicit the patients, but you don't own them. But he's absolutely permitted to tell patients he's leaving. And in today's day and age, you can just go right on Google and find out where someone went. So it's a very subtle process. I actually have doctors I counsel on this in terms of, okay, you have a restrictive covenant, don't solicit patients, don't solicit staff, but it's okay to tell people where you're going. That's not a solicitation, so to speak. You really have to do a balancing act between protecting your business or practice interests and the public right to choose their own healthcare provider. So now let's talk about hiring other staff, not professionals, licensed professionals in your office. Let's talk about ancillary personnel. Now, this could include some licensed professionals like PAs or APNs, but I'm talking really more about non-licensed staff during this portion of the presentation. So just a couple tips here. These are my opinions. If the practice is located in an area where another primary language is spoken, in my opinion, it's wise to hire individuals who speak that language. Very often here in the New Jersey, New York, tri-state area, we have large Hispanic and Spanish-speaking communities. And in those denser communities that are more urban, I always advise my medical practices, you may want to hire someone who is bilingual. It may help you communicate with staff. It may help you communicate with patients. Now, these individuals who are bilingual technically shouldn't be serving as interpreters with patients. Technically, you're supposed to have certified interpreters dealing with patients and your practice, making sure patients truly understand medical care rendered to them. But most practices in reality do allow bilingual staff members to serve as interpreters unless they perceive that there's some type of language breakdown and that different concepts are not properly translating. If the practice is located in an area where another culture is predominant, in my opinion, it's wise to hire personnel who are aware and respectful of that culture. So these are different things that you may want to be mindful of as the demographics of your community evolve over the years. The composition of your medical practice can reflect itself on the community. Some practices will say, we're not getting any new patients. Why is that? And I say, well, what's the demographic of your practice? And is there a large Asian culture, Spanish speaking culture? Is there a large population of X or Y or Z? And we just talk about these types of things because some people have biases, implicit biases. They want to go to, sometimes, not always, but some patients want to go to healthcare providers who are similar in language or culture to them. So it's just simply worth being mindful of that. It can decrease potential liability if you hire individuals who are similarly cultured or speak similar languages, but it can actually derivatively increase patient volume and revenue, for the reasons I just described. Let's just have a few words about front desk staff. As an aside, I do have a separate presentation on front desk staff, which I've put together over the last few years, and I think it's worth mentioning to you, at least that I have it. But in a nutshell, I will tell you this about your front desk staff. Front desk staff is what makes or breaks a practice. We need the doctors, we need the licensed professionals, we need great practice managers and ancillary staff, but look at the individuals who are working behind your front desk. Are they respectful to patients? Are they focusing on patients and not looking at their smartphones? Are they properly respecting patient concerns? Are they, to the extent they're responsible for it, properly timing appointments and properly reacting to patients who, for example, may show up late or may have a challenge with understanding their insurance? If you feel that you've suffered a decrease in revenue or patient volume, that's always the first question someone like me will ask you. How's your front desk staff? And another important bit of information, and if you want more of it, more specifics, really be happy to give you that separate presentation. But for your purposes, consider how much is paid for that position. Front desk staff are typically the lowest paid staff members in a medical practice, but they have so much vital importance to patient retention and patient volume. And most patients who are dissatisfied with your front desk staff will file bad online reviews of the practice. Now think about that. For a doctor or practice manager, you work really hard to make things work properly, but because your front desk staff wasn't measuring up, all of a sudden you get bad, negative online reviews. So they are an extension of the practice, and I'm simply encouraging you to spend a little time looking at them and training them properly and retraining them if necessary. Few words about the ADA, the Americans with Disabilities Act. When you're hiring staff, or you've hired staff, you have staff and they have suddenly developed a disability, or you have someone who applied for a position and they are disabled, have indicated to you that they're disabled. You do not need to hire someone if their disability will interfere with the performance of their job duties. Now that's very vague, but I will encourage you all not to be discriminatory in making that decision. There's plenty of individuals who are, quote, disabled. I don't even like that term, but there are plenty of individuals who have disabilities who are quite able with accommodations to do wonderful services for medical practice and perfect job functions. So in my opinion, written job descriptions for certain positions is vitally important. If you have medical assistant or a front desk person or a lab tech or this or that other individual, write down, and really beyond ADA reasons, it's a good idea to have written job descriptions for your staff because it helps solve a lot of problems later. It also spells out rules of engagement when you're hiring, and it helps you, or at least develop a roadmap for you if you need to fire someone. So back to the ADA. If the job applicant's disability will not permit them to do the job, even with a reasonable accommodation, which is the buzzwords, then there's no violation of the ADA. Here's some examples of reasonable accommodations for disabled individuals. installing a ramp, tactile labels for visually impaired people, modifying certain equipment, or think about ergonomic chairs, the cushion hand rests for typists, etc. These are reasonable accommodations. So the courts in the United States, as well as in Pennsylvania, apply different standard. It's under one of your primary cases. It's really a balancing test. And it was decided by the Equal Employment Opportunity Commission to be enforced on a case-by-case basis. Courts want you to look at the cost of the accommodation, how much is needed to put in this ramp, how much is needed to have this type of chair, to do this kind of thing. Can that accommodation for the disabled person help him perform essential job functions? That's also part of the balancing test. Now, if you violate the ADA, for example, and an individual who works for you or who is applying to be hired by you, if they file a complaint with the Equal Employment Opportunity Commission, the EEOC can find against you. They can fine you if you have somehow violated the ADA in handling an employee's disability. They can force you to reinstate an employee if you have parted with them because they're disabled and you did not afford them a reasonable accommodation. And they can require you to reinstate that employee with back pay. And in some states, including Pennsylvania, you may be required to actually pay their attorney's fees. So it's a sensitive topic. I would encourage anyone to seek counsel if looking to part with staff or have an applicant apply to work on your staff who has a disability. Anyone who knows me here will know that I always say it's very important to have great documentation, not only for everyday business operations, but if you're looking to fire someone from your practice, it's so important to have well-documented personnel files. Be very specific in them. If your policy manual, for example, requires you to give warnings to employees and that's not required under the law, or if your policy manual says you must discipline employees and that's not required under the law, then do so and document it. I tell most practice managers when they say, I don't have time to do X, Y, and Z, every time this one messes up, I can't simply just always send her an email or always give her a warning, etc. I totally get that, and that's fine. But at a minimum, if someone is chronically showing up late or using profanity in the office or not getting along with staff, etc., or doing anything wrong, email yourself at a minimum. For example, from practice manager to practice manager. Abigail, yet again, called out sick on Monday and then called out sick on the next Friday. She's constantly sick on Fridays and Mondays, right? Just keep a paper trail. So even if you have to email yourself, just to have good documentation, that's fine. Someone like me who gets called in to help with terminating staff, I also get called in to help with hiring, but more often it's to terminate staff. The first question I will say is, do you have a good personnel file, or have you emailed yourself about the things that this individual has done incorrectly? So paper trail is key. And also very important, in my opinion, to have good employment manuals or employee handbooks. That's the same thing. So you do spell out the rules for all your staff, along with written job descriptions. Then it becomes extremely easier to let staff go. And if you ever need help doing it, you can always feel free to give me a call. I'm morbidly very good at it. So I always, moving on to the next topic, I always tell practices to perform background checks on all professionals who are coming to work for the practice. So see if their license is valid and unrestricted. Check to see if there's any other license restrictions or elements of discipline that are public in nature. Ask them to produce a self-query, for example, from the National Practitioner Data Bank. Make sure that their CV is accurate. And we're going to talk about that with ancillary staff as well. Check their CV. A lot of people lie on their CVs. Call prior employers and verify employment. Now I can't say that's a per se rule. There's sometimes when doctors will say, well, my current employer doesn't know I'm looking. I totally get that. But as a general rule, if you can, and with permission, check with prior employers if there were issues. Now, the different states have different laws on what former employers can tell you about their former employees. I'm very mindful of that, but I think at a minimum, it's important to try to check an individual's former employment history and performance. Run a national practitioner data bank query or have them run it, as I said. Look at the State Board of Medicine history for that particular professional. Look at the Office of Inspector General website and any debarment searches with Medicare, Medicaid to make sure the individual has a clean record. Check their social media if you can, and there's a lot of nuances to that, but it certainly doesn't hurt to try and see what's out there. For example, a practice that I represent was looking to hire a new doctor, and I took it upon myself to look at their social media. The doctor had very few privacy restrictions on his social media, and I was able to see pictures of partying, pictures of a politically charged nature, and lots of pictures of drinking, which I guess falls under the partying heading, but lots of pictures of drinking and drinks. And I was concerned enough to warn my client, and they chose not to hire that doctor. Also, one last tip on this, inquire of these doctors or professional applicants what their history is with audits. Do they have any pending or recent audits? Because audits follow the doctor typically. They will follow a physician from practice to practice. And that's one reason why doctors try to leave practices and go to another one. So it's quite possible a doctor who's applying to work for your practice is trying to avoid the strangulation of an audit at another practice. So it's worth asking about that. And if there is an audit pending, fully evaluate it before you extend an offer to that doctor. I also recommend background checks on any non-medical employees. Again, check their CV. Don't just call references, call prior employers to verify employment. Check their litigation background, which you can check the state docket online. Feel comfortable with the longevity that they've spent at prior employers. Is it a sketchy or spotty resume? Have they only been here 2 months, there 3 months, there 6 months, there 1 month? If you're seeing this kind of sketchy work history, you can expect the same. So why do you want to invest the time, money, resources, and manpower to train someone who historically doesn't stay at a practice more than 3 months? Worth thinking about. Also check their social media, just like with professionals. Take the time to speak with them to see if your gut tells you that they're going to be a good fit. And then lastly on this topic, I would encourage you to give some thought to phantom job applicants. What are those? You know, it's interesting. During COVID, a lot of doctors and practice managers have been reporting to us that because employees want to stay home and collect unemployment, there's different state requirements to be eligible for unemployment. And obviously those out on unemployment get different stimulus packages through the government, financial in nature. So there's a populace of employees out there who want to stay home. They don't want to come in, they want to collect unemployment. Based on the different state requirements, many state departments of labor require those employees to show proof of job searches, interviews, etc. So many times employees will respond to ads you've placed and then never show up. But they're only doing so to go through the motions for the Department of Labor so they qualify for unemployment. So just be mindful of phantom job applicants. It's a thing. I'm sure many of you listening have experienced it. It's frustrating. Why are these people not showing up? I'm wasting my time. I can encourage you to place better ads and to fully vet those interviews as best you can before they take place. Okay, a few words on HIPAA and OSHA. So make sure all employees that you have on staff with you and that you are hiring are aware of HIPAA and OSHA regulations. New hires must be trained in those areas as well as existing staff. There's timelines involved with that. For your purposes, consider annual training in HIPAA and OSHA for your staff. And then those trainings in HIPAA and OSHA must take place for new hires within 30 days of their commencement of employment. Have policies and forms in place for HIPAA and OSHA. Make sure, as I said, that the staff is trained on that. Keep proof that your staff underwent this training in designated binders, like if you have your HIPAA manual, your OSHA manual, put the training certificates that you get or generate annually in those binders or manuals so you retain them. And you should be keeping those records for at least 3 years. Few words about sexual harassment and discrimination, worth talking about when hiring and firing. We have seen a major uptick in harassment and discrimination claims that have arisen since the Me Too movement, the Black Lives Matter movement, frankly, the COVID pandemic. These are all things that have happened, and socially, the mentality of employees appears, in my mind, to have changed a little bit. There's more people, and that's not a bad thing, but there's more people who are aware of their rights to have a workplace that is free of sexual harassment, discrimination, bias, implicit bias, to have a workplace that is a safe place to work during COVID, to have compliant workplace. So I just wanted to take a moment to talk to you about sexual harassment and discrimination. Very important under Pennsylvania law to have policies in place on both of them. Make sure all of your employees sign off on those policies. Typically, we see those policies placed into an employment manual, but you should have separate harassment and discrimination policies in place. Enforce a zero tolerance policy on it. It will not be accepted in your practice, period. All complaints about harassment and discrimination must be investigated. And typically that falls upon someone like you, a practice manager, or someone like me, a workplace complaint investigator. If you're having any allegations of workplace harassment or discrimination, you can always feel free to give a call. I can kind of walk you through it a little bit. If you needed an investigation, we do that too, but it can be a tangled web. So if you need some guidance, I'm happy to lend that to you. Also, if the investigation reveals that, yes, there was a sign or incident or incidents of harassment or discrimination, terminate the staff member or members who did it. You may also have to refer the entire issue to the Equal Employment Opportunity Commission or to any other local or federal agencies like the Office of Civil Rights. Pass that along in terms of the severity of the complaint. So if something serious has happened, you may not strictly be able to squash it within the office. On sexual harassment and discrimination, you should also have annual training on these subjects and document it, have certificates and retain them for 3 years. And then down here below, and if you'd like to obtain these slides, I know I or your association has them, but I have included some live links here. For more information on harassment and discrimination in your workplace or what an employee needs to do to file such a complaint, you can go to these links. very important on harassment and discrimination to know that these types of complaints can be against regular staff members, supervisors, or the physicians. No one is safe. And all employees of the practice, including the highest level staff and supervisors, must undergo that training. So, as I was saying before, firing an individual, having that personnel file is crucial. Try to play nice and minimize any negativity. Nothing good ever happens when it devolves into negativity. I'm going to give you an example. I'll give that to you in just a moment. Do not let it descend to name calling. You can't control your employees' actions. Obviously, they're going to have feelings, big feelings about being terminated, but you can control yours. Everything that you say can and will be used against you if possible. So be very judicious in what you do say. My opinion, it's best to also prepare a letter and provide the letter to that individual at the time of termination that documents the termination. Having counsel do it obviously is recommended in my mind, but you don't need an attorney to terminate someone. And then a word about voluntary resignation, which kind of ties into the little story that I wanted to tell you, right, about playing nice. So we terminated for a medical practice a couple of weeks ago, an employee. This employee, we were asked to do so by the practice. They did not want to do it themselves, which is fine. This employee had been out with a positive COVID diagnosis the first week of December. Well, fast forward to the now second week of April, she has not yet returned. Doesn't respond to the doctor and practice manager's calls, doesn't respond to the practice manager's letters, doesn't respond to emails, texts, etc. So with a COVID positive diagnosis in the 30-something-year-old woman, she failed to return to work. I was tasked with sending her a letter. I left her a phone message and then I sent her a confirming letter indicating that the practice has made various attempts to reach her and that they now consider her to have voluntarily resigned from her position or abandoned her position. Well, I sent it by email and I sent it by mail. This is a woman who no one's heard from since December. Now, for anyone who's saying, well, what if she was dead? Or like, didn't they worry that something was seriously wrong with her? As an aside, staff members in this practice knew she was living the vida loca. She was on social media. She was taking trips. She was having vacations. She was having a grand old time. Everyone on our end knew she was alive and well. So not responsive to the practice. I sent her a letter confirming that she voluntarily resigned. I also sent a letter and told her I would send a letter to the Department of Labor. No sooner had I sent that letter, within about, 20 minutes, I got an angry phone call from her, the employee. I've been out and I keep getting a COVID positive result and I can't return yet. And I tried to explain what the CDC says on positive test results, how that can linger, and that does not mean that she's not cleared to return. I started to get explanatory with her. She was trying various ways to say, I still need my job. I can't come back. I have children. I can't come back. I have a mother who has to have surgery. All of these things. I went through the analysis of she did not qualify to remain out of work. She did not apply for family leave, all of these things. And finally, towards the end, I said, well, I'm very sorry. I wish you all the best, but the practice is going to consider you to have resigned, and we've notified the Department of Labor. And then she got loud and said, I'm calling OSHA, I'm calling the Board of Medicine, I'm doing this, I'm doing that, I'm going to make HIPAA complaints, I'm doing all of these things, and I'm going to punish this practice. So what I want to tell you, and it ties in as we nearing the end, it ties in with what I'm going to get into shortly about former disgruntled employees can become extremely vindictive incredibly quickly. So if you do have employees who are not showing up, not measuring up, I would encourage you to consult with counsel. When thinking about former disgruntled employees. Be very careful. They are not your friend and are easily your foe. They can be vindictive, as in the example I just gave you. They can cost your practice money and reputation. You'll see things like bad online reviews, administrative complaints to the board, to a hospital that the doctors have privileges at, to different agencies like OSHA or the Office of Civil Rights, which enforces HIPAA complaints. You'll see complaints fired off by employees who are upset to insurance carriers, the DEA, the Office of Inspector General, the Office of the Insurance Fraud Prosecutor. I've even seen angry former employees fire off complaints that are fictitious to the police. So consider the proper way to handle termination. And it's really to have great documentation, give some warning if you have warning or advance notice, consult with counsel, and then terminate as appropriate. Don't let it devolve. Just be quick, rip the Band-Aid off, and get it over with. And certainly there's more nuance to it, but we only have an hour today. So as we come to a close, I did want to give you a little COVID perspective here, which I've been kind of talking about along the way. So employees, not all of them, but some of them feel unsafe and at risk in a medical practice. They don't think necessarily that it's a safe place to work. Maybe they have feelings about PPE or measures in place to clean high touch surfaces, etc. Some employees, as I've said, might want to just stay home and collect unemployment. Some employees have children at home who are not fully back to school. The pandemic is taking a physical and emotional toll on all of us and on all healthcare workers, most importantly. Employees, as I've said, are trigger happy with compliance accusations. There is an array of conflicting employment laws out there in terms of what you can and cannot do with staff who's off for a COVID-related reason. Now, we have separate presentations on these COVID different concepts, so I'm not going to get into the weeds on all of them here, but there is some disparity over the different states and the federal government in terms of what you can do with staff who are out for COVID-related reasons, including kids being home, etc. And then as far as this pandemic is concerned, I tell practice managers, arm yourself with knowledge, policies, training, distancing, disinfection, PPE, proper screening. All of these things, when you really try to put them together, will help better settle your staff and make them feel very, or as comfortable as you can in having them maintain their employment, return to work, be accountable, etc. And then also make sure, if you have to, furlough staff. If you had to, lay off staff, terminate when necessary. And I gave you the example of this woman. She never came back. There's a lot of employees out there who think, oh, you know what, I'm out. And I'm just going to keep the employer on the hook. I'm going to say I have kids at home. I'm going to say I have this, I have that. I have a mother who was having surgery. I had a prior diagnosis, and they just string it out. So it is very complex. And I would encourage you, talk to your attorneys for the practices, because they can help walk you through it. I did want to give a special thank you to MGMA in Pennsylvania for having me. And I wanted to also just give you a little recap here before I go through some questions. Be very judicious and contemplative before you hire staff. Have an employee handbook and policies and training, etc. Maintain detailed personnel files on all employees. Email yourself if you have to about chronic issues. That way it's documented, because anyone defending your practice will say, well, it's not in writing. I'm going to have a hard time proving that. Maintain, next one. Ensure and document proper employee training. Keep it for 3 years. I always tell practice managers, I give them this tip. If you're happy with your staff, buy pizza for them every now and then and say thank you to them. It goes an incredibly long way in terms of psychic income. And also, if you're ending that employment relationship, do so properly, timely, when it's appropriate, and do it appropriately. So you have to be prepared for some fallout as it may arise. But if you do everything right, you really don't have to worry about the fallout. Just be prepared that it might happen. And with that said, I thank you for your time today. I'm happy to take a look at some of these questions in the chat box. Let's see. All right. So you're going to hear me reading and talking to myself. Could not agree more with your comments about front desk staff. That's great. You go tell my husband you agreed with me, because he doesn't think anyone agrees with me. I will tell you all, I do, and I don't want to peddle my wares to you, but I have a front desk staff presentation. It fills an hour, and boy, it's really good. Okay, if you are having revenue loss, patient decrease, if you're having complaints from patients, if you have patients leaving and you don't know why, really look at your front desk staff. And there's plenty of videos on YouTube about how bad staff at the front desk can really cost you patients. They're almost laughable videos, but subtle advice in those videos to help you better train your staff. So if you ever want me back again, folks, have me do my front desk staff presentation. Do I have a link for the corporate practice of medicine doctrine? I do. I do have one. I can either provide that to Erin to send out, or I don't know if you can see, or you can email me. You can email me and I will send it to you. Question, did I hear you say that it is legally permissible to ask staff to become vaccinated? Asking is one thing. Has anyone made it mandatory? So the answer is, the way you've asked it, it's a little bit more of a subtle answer. The Equal Opportunity Employment Commission has mandated on a federal level that it is completely reasonable for a medical practice or any other employer to mandate that all personnel be vaccinated. There are very few exceptions to that, one of which is if it would cause some type of health result, which I don't really know what health result would happen by getting the vaccine. The other exception is if the individual has a strongly held religious belief in not getting vaccinated. Those are the quote anti-vaxxers. Those are the people, and I don't mean any offense to them. There may be plenty of you on the phone. Anti-vaxxers are those they're opposed to vaccinations in the first place. So please don't take any offense to that. But anti-vaxxers, or then there's certain religions out there who are strongly against vaccinations altogether. But I will tell you, Natalie, it is absolutely legally permissible to mandate that your practice members get vaccinated. And there's plenty of reasons why, which I won't bore you with. I create policies for practices. We have policies mandating the COVID-19 vaccine as well as flu vaccines, et cetera. So if you have any interest in obtaining them, feel free to call me or reach out to me. But yes, it can be mandatory in your medical practice unless one of those exceptions applies. So, oh, someone said happened to me yesterday. Okay, never mind, I found it, thanks. I think that was to corporate practice of medicine doctrine. Question, if there is a position that was part-time that increases to a full-time position, is the practice obligated to promote the part-time employer to this increased full-time equivalent, or would they need to apply/interview for the position? In Pennsylvania, you can absolutely just promote that individual. They don't need to apply to it. Now, there may be, I don't know the size of your practice, there may be internal corporate rules that mandate that all individuals changing from part-time to full-time or FTE must apply. But as a general rule, no, an individual can be promoted for that position and would not need to separately apply. And I think that is it. So you have me multitasking here. I will say this, ladies and gentlemen, it's really hard to be practice managers right now. You are dealing with all of these compliance restrictions, all of these additional things that you have to do within your practice, and the staggering of patients and the compliance requirements and the staff that's revolting and staff who doesn't want to come back in, and some are doing telecommuting and some have kids at home and some are reading the internet thinking they know all of these laws, and some are saying, you know what, you can't mess with me, I'm just going to stay out, I'm going to say I'm disabled. You guys have really tough jobs. I respect that. I feel for you. I will give you this parting bit of advice. Don't go it alone. Seek advice. Watch presentations like this. Go to your association. They have tremendous resources. Feel free to call someone like me if you ever needed help with that. And I'm always around to help give you guidance. So thanks for joining me today. And I look forward to next time.
Thank you so much, Nan. You really have provided a lot of information and a lot of great advice. I know I was writing down some of the recommendations, and I think for all of us, you know, this is either reaffirming things we're already doing or you know, giving us new ideas and new directions to go, and to also have you as a resource for future presentations and maybe for any of us individually to reach out to. So thank you very, very much.
My pleasure.
And I also just want to remind everybody that if you are looking to make sure you get credit for this time, to make sure you record it on the MGMA website. If you're looking for, you know, the hours that you need, this is a good time to do it. I think there's a total of 6 hours available between the 2 days. So just as a reminder to make sure you record that on the MGMA website. And also just to let everybody know that we will reconvene tomorrow, and Aaron will be sending out an email soon, sometime I think before the end of the day, with the links for tomorrow. So thank you again, Nan, and I hope everybody enjoys the rest of their day.
Thank you. Have a great day.